something that I want to point out, the difference between emergency and non-emergency. Emergency, the duration for the emergency is 60 days. Right. At the end of 60 days, it automatically dissolves. So now, oftentimes you may wind up having to file, at the same time you file your emergency petition, you may wind up having to file your permanent one also. And no, you don't get a discount on the price. No.
They used to have a combined petition, and they did some revision stuff to the code, and they changed that. And
the reason they changed it? People were waiting too long, waiting for emergencies, and then running down to court. And the probate judges said, you know, these people should have been here long before this emergency. And that's why the state legislature actually took away that combined petition. Because and I used to tell people, wait until there's a problem. You know, within a week we can have that guardianship then. And then at the end of 60 days, it'll just automatically turn into a permanent. And then about 6 years ago now, maybe even longer. When was our major? 6 years ago. They took that option out. Yep. So now the legislature is saying, look, if you know you need to do it, do it. Don't wait for a problem. Don't wait for a crisis to arise. Because it was putting a big burden on the courts, because the court has to drop everything else. Because Judge Walk is just sitting there twiddling her thumbs with not much. So,
the other thing is our cleverly named emergency hearing, which is not a typo by Mark. Technically it is a pre-hearing emergency. If there is something so egregious and so threatening to the proposed ward that they cannot wait 3 to 5 days, then we do, if the circumstances support it, we can do a pre-hearing emergency that will last only until there is time to do the hearing. And it is typically limited to conducting certain things. If somebody had an accident and there needs to be discussion with doctors, and there needs to be a transfer from one facility to another, or there will be an imminent emergency threat to this person if they are not able to make these decisions, that's the kind of thing that would allow for an emergency hearing. I will tell you, if you file a petition, the emergency petition is sought on the emergency petition. So you file an emergency, and within that there is a box that you check that says we need a pre-hearing emergency guardianship because, and you need to state facts. That petition, I just said a minute ago, you can file a petition with you, like mom and dad can file a petition, or mom and pastor, two people with knowledge can file a petition. This has to come with a supporting affidavit from a doctor, psychologist, or licensed clinical social worker. Two lay petitioners can't petition for a pre-hearing emergency. And
that they are sticklers for that.
Because it's right there in the law.
There's no way around it. Even if it's a non-medical issue, a medical doctor or one of the other two classes of people have to sign, and if they don't initial the right paragraph, it ain't going to happen. The judge can't do it. Who can apply for guardianship in Georgia? Any interested person can apply either for guardianship or conservatorship or both. You do not have to have any particular relation with the person that you are seeking guardianship of. That surprises many people. Many people think, well, I'm mom, I'm dad, I'm the only one that can do this. Someone else can actually do this. So, and this has actually occurred where somebody was living in a personal care home, didn't have a guardian. And it got to the point where the personal care home needed to know who could make decisions, and the family was saying, we don't want to do it. Well, someone else had to step in and do it. And that got the family all upset. So.
And you don't have to be seeking to be appointed as the guardian or conservator. And I don't know if you're going to get into that. If you are, like, I can say, probate judge in DeKalb County, Mark's not doing well. He needs a guardianship. I don't want to be it, but I just thought you should know. And then the court will go through all of those steps, analyze it, and if he needs somebody, then there are default people who are in place, the county guardian and the county conservators, who can serve in that capacity. Or if somebody else steps forward and says, okay, I'll do it, then that can happen. That you don't have to be asking to be that person in order to file a petition to try to protect somebody who needs it.
One thing we want to emphasize, you do have to have either 2 petitioners, 2 people have to allege that this person needs a guardian, or 1 person and a doctor's affidavit. So, you know, one person can't go down to court, fill out the forms, and be named the guardian. 2 people have to go down, or 2 people have to complete the petition and submit that. Because sometimes people are surprised when they get down to court to file, and then they're told, nope, you need 1 more person on here. And they're like, well, who? Anybody that has an interest in the individual. Anybody who has personal knowledge about that person can be a petitioner.